Termination of a labor contract is an event that terminates the employment relationship between the employee and the employer. In particular, there are many cases of termination of labor contracts, such as the labor contract expires, the work stated in the labor contract has been completed, both parties agree to terminate the labor contract, the employer lays off the employee due to structural or technological changes or because of economic reasons, merger, consolidation or division of the enterprise or cooperative. In case more than one employee face the risk of unemployment for economic reasons, the employer shall propose and implement a labor utilization plan in accordance with Labor Code. Specifically, the labor utilization plan must contain the following main contents. List and number of employees who continue to be employed, employees sent for retraining to continue using. List and number of retired employees. List and number of employees transferred to work part-time. Employees must terminate labor contracts and measures and financial sources to ensure the implementation of the plan. In case the employer cannot employ and have to dismiss employees, the employer shall pay job loss allowances to the employees. Accordingly, the employer shall pay a job loss allowance to an employee who loses his/her job and has worked regularly for the employer for 12 months or longer. The job loss allowance is equal to 1 month's wage for each working year, but must not be lower than 2 months' wage. The working period used for the calculation of job loss allowance is the total time during which the employee actually works for the employer minus the time during which the employee benefits from unemployment insurance in accordance with the law of social insurance and the working period for which the employer has paid a severance allowance to the employee. The wage used for the calculation of job loss allowance is the average wage in accordance with the labor contract during 6 months preceding the time the employee loses his/her job. The dismissal of more than one employee in accordance with this regulation may be implemented only after discussion with the representative organization of the grassroots level employees collective and notification 30 days in advance to the provincial level state management agency of labor. It is important for the employer to consult with dispute lawyers specializing in labor matters for the avoidance of potential dispute with the employee, and cause negative social impact when deciding to terminate contract due to economic reasons.